DROOM@hymansanchez.com, and at the end of the presentation we'll all go through them and answer your questions. As we're going through today, you're going to need some passwords, and we'll give those to you periodically through this so that you can get your CMCA credits. For those of you who don't know me, my name is Debra Oppenheimer. I'm the covenant enforcement attorney here at Hyman Sanchez. I've been here going on 9 years. As I like to tell people, before I was an attorney at Hyman Sanchez, I used to be a district attorney. I used to tell people to follow the rules, and I'm still telling people to follow the rules. We're going to try and work through the process today of what those rules are and how you enforce your covenants, specifically when it comes to the architectural review process. As we go through this today, you're going to hear me talk about ARC, DRC. I'm referring to the Architectural Review Committee, maybe the Design Review Committee. Each of you may have different terminology in your declaration, but we're talking about that same committee, the committee that works with the architectural review process, the one that gets those submissions for landscaping or gets the submissions for how they want to build something on their property, and how those are handled in your communities and what the best process for those are. I want to let you know that we have some additional resources on our website if you're not familiar with it, at hymansanchez.com. We have lots of articles, newsletters, blogs to try and keep you informed. If you're ever looking for some answers, I would highly recommend you look there first. We also have a newsletter that if you're interested, you can sign up for that. Contact Andrea Daigle here at our office, and she'll be happy to sign you up and get you copies and get you on the receiving of that newsletter. Okay, so moving along into the architectural review process. The first thing that you need to be aware of is where to look for the information that you need. So when you're starting off on the process and you're trying to determine, how's the process work, where do we go to, what are we looking for, you want to start with the most important document, of course, which are your covenants. And that might say the declaration, it might say protective covenants, CC&Rs, covenants, restrictions. There are different terms, but they're talking about what's recorded with the clerk and recorder that binds all the properties within your association. That's going to be your primary document. That's the document that almost always has a provision in it that sets forth that prior to any external modifications being made in a community, you have to have pre-approval. Obviously, the second most important document when you're talking about architectural review process are your rules and your regulations, because oftentimes your documents yourself are going to say you need to have the pre-approval of your ARC or your DRC, but when it talks about what the specific requirements are going to be, those are going to be contained within your rules and regulations or your design guidelines. Now, the rules and regulations are generally created and crafted by the board of the directors for a community, and your design guidelines are generally created by the DRC or the ARC, possibly with the required approval of your board, possibly not. You have to look to your documents because that's going to be very document specific to each community. You have to then finally make sure that you have a covenant enforcement policy that gives you the direction on how these things are going to work together and how those things are going to happen. The first most important thing that you need to be aware of as a manager or as a board of director when you're looking into how do you enforce your architecture review restrictions is who has the authority to make those decisions. It's sometimes overlooked and assumptions are made that the board can just step in and make decisions about an architectural review, and that may not be the case. Oftentimes, the ARC, the DRC are given the authority to take action. They're the ones who are told you have authority to determine, to approve something, to deny something. If your documents specifically say that the DRC is the authority to make the decisions, your board of directors may have no authority whatsoever to make that decision. Now, if your board of directors is also acting as the DRC, then again, they have authority to take that action, but they're taking it as the design review committee. It's kind of like they have two hats. You take off the board member hat, put on your DRC hat, and say, okay, I'm acting as a DRC, and I'm going to make a decision on what's been submitted to me. If those are two separate groups, the board of directors and your DRC, then it's just whoever the governing documents provide that has the authority to make those determinations. You want to make sure that, again, you look to who has authority before you start making decisions. Now, in most communities, your DRC or your ARC are appointed committees. So if, in fact, the board finds or feels that these committees are acting outside the authority in their governing documents, The association may have the authority to remove a DRC or to remove certain members or to appoint board members onto the DRC to help control that. But if the decisions are already made by the DRC before the board finds out that these decisions are possibly contrary to the declaration, you may be stuck with the decisions that have already been made. It's not something that can be easily undone. That's why it becomes very important that the association remembers that committees are required to keep notes and minutes just like the board's required to keep notes and minutes of their meetings. So that way the board can keep an eye on the decisions being made by the DRC and understand and making sure that they're staying in compliance and they're acting within their authority. Well, how do you know if they're acting within their authority? Well, the first thing you've got to find out is who is the ARC, the DRC, ACC, who is that committee? Well, again, you're going to go back to your covenants and see who had the authority to appoint them. Was it the board? Probably in most governing documents, the board of directors appoints that committee. Now, in some communities, and it's a pretty small minority, but in some communities, the ARC or the DRC are actually elected by the homeowners just like the board. If that's the case, you're going to have some different, communication issues and some different relation as far as hierarchy between the board of directors and your ARC. So you want to look to your documents. Commonly, most of the times, it's an appointment. It's made by the board of directors. But again, we want to start with the covenants to determine that. Once they're appointed, then you want to make sure again that they're following the restrictions that are set forth in your governing documents. Most of the time your governing documents is going to give that ARC or DRC kind of some guidance on how they make those decisions. Now, if those decisions are make sure what's approved is in harmony with the surrounding community, that's something that can be more spelled out in guidelines so that, again, you're not asking the DRC to act very blindly without direction. If your governing documents give just that completely open-ended, the decision is the DRC's, and you really kind of want to make that more clear for your homeowners, that's a really good place to start is in your guidelines. And it's really important to have that so that your homeowners know this is what the board feels is appropriate, this is what the board is going to approve, because this is what they feel is in harmony with the community. And you want to make sure that's all in the guidelines. As I already stated, when you're talking the ARC or the DRC, sometimes they can be one and the same as the board members. In smaller communities where you don't have a lot of participation, it is not uncommon to have the board members wear those two hats of both the DRC and the board of directors. So what's the first step? First step obviously is getting that application in the door. Once you get the application in the door, you need to take a look at it. You need to make sure there are certain minimum things on that application. The first thing is a date. Now that sounds like, okay, that's kind of boring, that's who cares about that. But the reason the date becomes so critical is many, many declarations have documents which state if in fact those documents are not submitted by the certain date or they're not reviewed by a certain date, they're going to be deemed approved. So if you don't see a date on that application, later on down the road, that approval issue might pop up and be a problem. So let me give you that first password I was talking about. I told you to make sure we're going to keep you getting your CMCA credit. So that first password is going to be covenant, capital C-O-V-E-N-A-N-T. All right, so going back to the application process. After you've made sure that there's a date on it, here's an obvious one, but maybe not so obvious, make sure it's the date you actually got it. I've had many cases, ended up in a courtroom, and one of the first arguments we had is, when was the application actually submitted? And what happens is, sometimes it's purposeful and sometimes it's not. An application is filled out on one day and maybe it doesn't get mailed for 3 or 4 days. The mail takes a few days, and by the time it gets to your office, the date that it's received by the association to be reviewed might be anywhere from 5 to 7 days after that date that's on that application. Well, the association gets 30 days from the date they receive it, so there needs to be a process in place where it's either stamped the day it comes in, it's logged the day it comes in. Somehow there's a notation to mark the day that the HOA got that application, and it needs to be a constant process so that if we walk into a courtroom, the defendant at that point in time, the homeowner, can't say, well, they just wrote that on there to cover their their tracks, we can say, no, this is a constant process. It's followed every single time. Here's the log that we use to show where this came in. Here's the date it came in. Here's where it was in the middle of the page. Again, showing you have a process in place. One of the things that is important is having the same process. And one of the things that we really encourage is, even if you've got a homeowner board that's really trying to be very easy, very friendly with their homeowners, and they say, oh, the homeowners can send the DRCs direct to the DRC chair. That can raise some problems, because what if that chair goes on vacation? What if the mail has an issue? There's no constant process to say, here's the receptionist or here's the manager who gets the mail every day on this time, and here's the log where they've logged in every application. When you make it a constant process, especially if you have a management company and you use that management company to log things in, if we end up in court, that date is not going to be an issue, because you're going to have a log that shows when it came in. That form's going to be stamped. We're going to know the date the application came in. The other way to actually deal with the date issue is to look to amend your documents. To remove that language that says, if not approved within 30 days, it's deemed denied. You want to change it so it says deemed denied as opposed to deemed approved, because then no longer are you ever worried about the date. You've just pulled that out of the mix. The next thing you want to make sure that's on that application, again, it seems fairly obvious, but be amazed the number of times we don't know where to return the approval or denial. So you want to make sure you got a name, you got an address, you got a phone number, maybe a fax number or an email, so that when that decision is made by the board, you can get it back to the homeowner in its place, because a lot of homeowners obviously are off-site, might have this as a rental, this might be an investment property. You might have someone who has 2 homes. Again, you want to have a good address that you can get an answer back right away. Finally, again, we've broken this down into many stages, and you're going to see this in the next few slides, but at the first stage, what's the work you're going to do? Don't make assumptions. What we often see that runs into a court battle is something that says, I'm going to build a shed to match my house. It's that general, that lacking in specificity. Well, what that homeowner might think matches his house and what the board might think matches his house may not be the same. So we really want to work to make sure that what we're looking at and what we think we're approving is really what's being submitted. So you want to have more specifics there. If you're going to build a shed, how high is the shed going to be? Where's it going to be located? What's it going to be made out of? Color and materials becomes critical, especially in communities that absolutely prohibit things like metal sheds. I've had a number of times where a homeowner said, I'm going to build this shed. Nobody asked what materials he's going to build it out of, and lo and behold, he puts a metal roof on it, and the board is furious. It depends on whether or not the application said what kind of shed he was going to build, whether or not he said he was going to have a metal roof or not. If he didn't say what kind of roof he was going to have and it was just signed in blank, guess what? You're stuck with it. If you don't want metal sheds, if you don't want metal roofs, you need to have somewhere on your application where it says they're not allowed, and you need to mark that down, because again, if it's not marked and it's signed off as approved, you're going to be stuck with it. The next thing that you need to look for on your application is you want to look and make sure that all the things were turned in together at the same time. If you have a fee that has to be paid when that application comes in, you need a check mark somewhere, either on your login sheets or on your application, to show in with the application came the fee that was required to submit that. If there's going to be that you have to have multiple copies because it's going to go to multiple people in multiple places, then you may want to make sure you have all those copies. You want to make sure that if a homeowner is going to ask for a variance because he knows this isn't allowed, that be spelled out very clear up front on that application and directed. And we'll talk about variances more a little later on, but you want to make sure in that application when you're checking it in that you got everything you need to have. And it needs to have the date that it's planned to start and it's planned to end. Now you can have different kinds of dates. You can say that they plan to start within 30 days of approval and it'll take so many months, or you can just have a drop dead date. But those dates become critical. Again, going back to your governing documents, a lot of documents say that an approval is only valid for a certain amount of time. That if you don't complete the work within a certain amount of time after you've gotten that approval, your approval expires. They need to resubmit. So you need to have some dates on there, again, because that also helps you on that homeowner who is not the one who's going to do his work diligently, but it's going to drag it out for months and months and months. So you need a start date and an end date. If a homeowner has completed the project, it's completed before they submit it, absolutely you need that date on that application of the date it was installed. Because if this comes up and you're going to end up in a lawsuit later, and we're going to talk about statute of limitations later, we want to know what date that thing was built. And so again, you need to have that information on your sheet, and you want to know and have it written down by the homeowner and have it in their handwriting. If in fact you don't get these things, again, I'm going to give you some more lists, then we're going to send back a letter to the owner. That letter is going to say, this is incomplete. It might be a process where the minute it hits the door, if the homeowner brings it in, the receptionist or whoever checks in those applications turns it around right there on the spot and says, I'm sorry, this is incomplete. You need to get me X, Y, and Z. And then in the logbook it says incomplete and refused. Again, what we're always fighting, what we're always trying to make sure that we're covering is that in fact that 30-day deemed approved does not bite the association. Okay, we don't want to get hit with that and have no way to refuse something. So we want to make sure that if we accept it, it's complete. We got everything we need. If it's not complete, we're turning it around right there on the spot. No verbals. No, I'm going to call the guy and tell him he needs something else. I'm going to make sure I make a phone call. We need it in writing. Okay, so some more attachments we want to make sure are complete when we get these things. When you have initial constructions in your community, these are items that are almost always required on your full set of plans. You've got to have the construction plans, you need to have your architectural drawings, you need to have your elevation drawings. Possibly you might need to have samples. It might be sample colors, might be color chips, it might be the things, those little boards that you get. It might be that you had to paint it on something. A lot of communities require that in addition to submitting a paint sample, they actually have to paint a 2-foot by 2-foot swatch of the paint color they want on their garage door, because we all know when we're looking at a little tiny square that's 1 inch by 1 inch, we're trying to determine what color it's going to look like on the house, and it's 5 feet across. We need to make sure we got a little bit better idea how bright that color might be. And so if that's part of your policy, then again, that needs to be notated somewhere on your application. That here's a sample of the color, and yes, I also painted it on my garage door as required so that the neighbors and or the board can go by and object and see if they like it or don't like it. If you're required to provide samples of the roofing material, samples of the rock, samples, boards, whatever it is, make sure that was submitted. Again, if it's not there, it's not attached, turn it around right there and send it back. One of the things that we often see that's part of the application is that there's attachments that are not necessarily what I've just laid out. Homeowner might have taken a photo of a neighbor's yard. Homeowner might have taken a photo of a color he liked, maybe of a front door that he wants to install, and he's attached that photo. You want to be very careful about photos. Whenever you've got photos that are part of your attachments, you want to make sure that if there's multiple photos submitted, and I've often seen handouts where they got them from the manufacturer, and there's not just one screen door on the page, there's 4 of them. And the homeowner's submission and application doesn't say which of the 4 photos that you're looking on this application he wants to use. If there's more than one photo of what it is they're submitting, they need to circle and initial the one that they're submitting for, so you have some specifics so that your board doesn't have 4 different board members take a look at 4 different photos and they all like one of them but none of them like all of them, and you really don't have a consensus because you don't know what they're really asking to submit. So if they're submitting photos, make sure there's notations on the photos, what they're trying to show you in that photo. Is it a color? Is it an item? Is it something? So make sure you've got that and you understand what you're looking at. If you're getting landscaping and grading plans, make sure they're legible. Make sure you can understand what you're looking at. Is this a plot plan? One of the easiest plot plans, back when they used to always give an improvement location certificate with your property when you bought it, showed the house, showed the lot lines, showed where it was in relation to the driveway, to the neighbors. Those are great to tell a homeowner, hey, go get that improvement location survey that you got when you bought your house and then draw on that. Just make a photocopy of it, draw on it, put your trees on there, put your driveway on there, put your sidewalks on there, because it makes it much more easy for anyone to look at and see the relation between the house and what they're trying to build. Make sure you can tell what it is they're submitting. If they don't have that, ask for a plot plan. You know, you need to know if they want to put a shed in their backyard, and you allow sheds, but they have to be 5 feet from anything else in any neighbor's lot. Well, how are you going to tell that if you don't have a plot plan? And you don't want to be having to rely on a homeowner go, I'll make sure I do that, but you don't have it written down what you're approving. Because if you don't have it written down what you're approving and you end up in court and it's just verbal, you're going to have a homeowner say one thing and the board say the other. And then that's never a good situation to go to court on. Finally, a lot of homeowner associations have acknowledgments on the bottom of their application. That acknowledgement might say generically that the owner promises that he's going to comply with all the covenants, and it has a signature beneath it. Okay, this kind of try and cover all my bases, and if I miss anything as a board member or an ARC member, won't get you very far. If you get a plot plan and you get plans that say, I'm going to install 4 cottonwood trees, and the board signs off on it, the fact that your covenants strictly prohibit cottonwood is not going to get you out of the fact you just signed off on it and you approved it. So this acknowledgement on the bottom of a page sent by the homeowner saying, I promise to comply, if he still asks to install the cottonwoods and the board signs off and says, sure, you can install the cottonwoods, he gets to install the cottonwoods. That acknowledgement that he's going to comply with covenants is not an insurance policy, and it's not going to get you out of that approval. A lot of your documents have in their provisions that an owner can ask for a receipt. Okay? And the reason, again, is to help the homeowner say, look, I submitted this. I got a receipt for the date I submitted it. I know the date. Everybody's comfortable with the date. It's in writing. It helps both sides. I would encourage that if your documents say that owners can get receipts, that become part of the process. I know a lot of management companies actually send an acknowledgement letter. We got the application on this date. It will be turned over to the ARC. That is a great policy. It's just like that log I talked about. It puts everybody on notice when they got something, and it really kind of firms up what the date was so we all know when our 30 days is going to run. Also, it always helps to show that if, in fact, the owner submitted plans, got that receipt for it, he's not going to make a claim that the board waived their right to review it, because if he submitted something and asked for approval, he's acknowledging he has to get approval first. Create a checklist. If you have a community that's not having their documents sent through to the board members, or sent to the manager's office, it's going straight to the DRC. Help your DRC out. Create a checklist of what they're looking for, what they need to make sure is attached, what they need to do, so that they're not trying to look through all of the governing documents each time something's submitted to them. Help them with a checklist to say they got all the things they need to have, and that they, in fact, are comfortable knowing what they should have. Now, one of the things that, again, we've kind of looked at and we've created is this very simple checklist. Again, what's the date it was received? Okay, always the most critical thing on any checklist. When's the deadline to respond? Have that on your list immediately. The first thing, so again, this person, if it's not the manager, this is more important for DRC members who are volunteers and trying hard to do the right thing. Help them out by having this checklist. And the second thing that should be on the top of this checklist is, what's their deadline? When do they have to have it back to the owner? And make sure you've read your documents enough to know, does the document say, I'm going to review it within 30 days, I'm going to issue a decision within 30 days? The homeowner will get an answer within 30 days, because all of those are vastly different. If you have to get an answer to the homeowner within 30 days, that means you need to make sure you put it in the mail 3 days probably before that 30 days runs, or you're going to miss your deadline. So kind of know when your deadline is and what it is you're complying with. Again, go back for the full, the slides we just looked at, and your checklist should be, was the fee paid? Is the application filled out? Is there a diagram? Do you have the right number of copies? Is this a request for variance? Because if it's a request for variance, that should take a different process, because that's going to be a seldom used thing, and it's going to get much more scrutiny, or it should get much more scrutiny, because they're asking basically to ignore a rule that's in place. So again, these kinds of things need to be on a checklist to help your DRC when they're looking at things. If in fact you determine that any of those things is not there, then the process should be very clear. This is incomplete, and we're sending it back to the owner, and we're sending it back in writing with a letter saying, this is why we're sending it back, this is what's missing. Do not send it back with a note saying, hey, send me these other things. Do not make a phone call unless you're doing the phone call in addition to what's written saying, this is incomplete, we need more items. Once you've got everything and you're going to give it to your ARC, you're going to give it to your committee members, or your board members, again, whatever your governing document says is the person who's going to review this. You're going to give it to them to review. Then we need to look to what's the process. What's the process that this ARC takes? What's the process about how things go through the process? Does your committee need to meet together? Do your documents say that the committee will meet and review these items that are submitted? Does it allow you to send it out? You might be allowed to send it out to an external architect who's going to review, who you're going to pay to get a professional opinion on it. Is he allowed to make the decision? Does it have to come back to the committee? Does the committee make the decision, or is it just a recommendation to your board of directors? You want to look to your governing documents and that you make sure you're going through these steps, and you make sure that, again, the time that you're spending supports what's in your documents and you're not just spinning your wheels. Make sure if your governing documents say, here's the criteria for approval, those are the things that you're looking for. Because if your criteria for approval is very limited to it's approved unless it's covenant prohibiting it, you have very, very little discretion. And your DRC can't be approving much or denying much because, again, your discretion is limited. If you've got broad discretion, then again, I'm going to go back to saying recommend that you put some guidelines in place so it's not a guessing game from your homeowners, and because you're going to get consistency there. You want that consistent approval. So again, if homeowner A submits something for a blue house, homeowner C submits something for a blue house, it's the same blue, they're not next door neighbors so that they're both getting the same color, but you're going to give them the same answer. You need that consistent application, and the only way that's going to happen is logs, guidelines, and following policies. Again, if you keep logs of what your prior approvals are, you're going to stay consistent. You have to be consistent. That's because when you get into a courtroom, courtrooms look at things and say, did the board, did the ARC act without bad faith, without being arbitrary, and without being capricious? Because those three factors are the factors that the case law in Colorado say is what that judge is allowed to review when he reviews those decisions. So if you can show by your consistent reviews and your consistent approvals that you're always allowing that light blue, or you're always allowing that mauve color because it's a light color and that's allowed in your community, then the court has to follow through and say, okay, there's no arbitrary conduct, there's no capricious conduct, and they're acting in good faith. When you have no logs, when you have no consistent application, it becomes much, much more difficult by a board or an ARC to try and show to a courtroom that they did not act arbitrarily. And then when you start having that problem, then the court could rule against you and make a finding that you can't enforce your covenants. So you always want to keep those consistencies and those logs. Okay, let me give you the second password, which is pool, capital P-O-O-L. Again, we want to make sure you guys get your CMCA credits. So we're going to move on to some of the newer issues that have popped up. And one of the things that obviously has popped up is renewable energy devices. Now, when we start talking about renewable energy devices, what we're really talking about is solar panels and windmills. Now, as many of you know, a lot of the older documents absolutely prohibit solar panels. If your documents actually do prohibit that, you don't have to take any further steps to deal with that, but you do have to know that the statute trumps, and the statute's now going to allow the solar panels. The law does still allow you to have some reasonable restrictions on those solar panels, and the same with the windmills. And those reasonable restrictions are going to allow you to put some aesthetic requirements in place. However, and there's always a however because we're talking about the statutes, and the statutes are going to say that those aesthetic requirements cannot make the solar panels less efficient and cannot make them cost more. Okay, so if in fact there's a significant increase in the cost or a significant decrease in the efficiency, your restrictions will be thrown out by a court. So what we would recommend is the best way to handle this, again, is put a policy in place that shows this is what we want, this is a recommended placement, but do know that if in fact one homeowner says, I can't put it on the back side of the building because I'm not going to get any sun, you're probably going to have to allow them to put the solar panels on a side of the home that you don't like because of that decrease in efficiency or in that increase in cost. So keep that in mind. We recommend that you go ahead and have your aesthetic requirements kind of set out in advance. It stops a lot of arguments and makes it a lot smoother process, but at the same time understand you're not going to get 100% because there's going to be those cases that you can't require it where you'd like to have it. On the windmills, these are ones that noise becomes an issue. A lot of these generators that are attached to the windmills are quite noisy, and so one of the things you might want to have as part of your application process when somebody wants a windmill is and that may mean that the board members or the DRC have to drive out and inspect this windmill to see how loud it is and see how loud this generator is, because you don't want to be approving something that's going to be so loud and noisy that you're immediately going to start getting the nuisance complaints from all the neighbors, because then you put yourself in a bind because you approved it and it's causing a nuisance. Once you approve it, you can't force somebody to remove it. So you want to get those inspections and review how loud something is in advance. The other thing to know about windmills and solar panels are ask on those cases, and sometimes your other documents as well, you may want to ask to make sure that you get the county permits from the homeowner first as part of their application. A lot of times your documents might say that homeowners need to go get those, but you may not have it in your application process. In this situation, I would ask that you actually make it part of the process, because a lot of windmills are going to be denied because of the height restrictions in the county and the city levels, and a lot of communities are going to have a lot of safety requirements on the solar panels. So you kind of want to ask your homeowner in those situations, go get those county permits first, then come submit to me, because then the ARC are going to have a lot less legwork. One of the things we can recommend, and you might want to think about, is on any approval, making a notation on that approval that your approval is the HOA approval only, that any required government permits, any required city permits, county permits, whatever that may be, are still required, and the homeowner is responsible for getting those in addition to the HOA approval. Again, if you separate that out and put that on your application form, maybe at the bottom, or on your approval letter, if you send out a separate approval letter, again, re-emphasize that that's incumbent upon the homeowner to go get that separately in addition to the HOA approval. Now, some counties are going to require the HOA approval before they give a permit, so it's kind of hard sometimes for you, the HOA, to demand that the permit come first, because the county's not going to give a permit until they see they get your approval. Douglas County is one of those. So work with your homeowner on that, but just make them aware they are separate processes that both have to be followed. Okay, so moving on to the other energy issues that have come up, which is energy efficient measures. And these are ones that we've seen a lot. And again, these are very common in your older declarations as being disallowed to begin with. One of the things that you'll often see is no clothesline. That's one of the older documents, and it was a very common restriction. Well, you can't allow that anymore. Now you have to allow a retractable clothesline. Another thing that often used to be completely prohibited was an evaporative cooler. Those were just not allowed. Okay, you can't do that anymore. So if your documents disallow those, you need to know that now, because of the statute, you're going to have to allow them. Again, you can ask for aesthetic restrictions. So if a homeowner wants that swamp cooler, you can ask them to put it on the backside if they're going to put it up on the roof, if they're going to put it on the side of the house. You can ask that there be some screening with some trees. You can ask for some bushes. You can ask for different things around those items to help screen it from view. So again, you're helping the community and the look of the community, but again, you're not restricting these things that are things that are needed. On the awnings, that's another one that comes up very frequently. If you have awning restrictions in your documents, again, you're going to have to allow them. But what you want to do is say, okay, I don't have to allow the really, really ugly ones. I can say to the homeowner, yes, you may have an awning, but you need to have one of these that are in these colors that are look more in harmony with the rest of the community. Again, your restrictions have to be in line with what the rest of the community wants. There can't be a significant increase, can't be a significant decrease in the effectiveness. So you can't say, oh, I see you like this really cheap awning that's $2. I want you to go spend $2,000. That's not going to work. But again, if you have two awnings and they're the same cost or approximately the same cost, and one is more in line with the look and feel of the community, you can certainly tell the homeowner no to this one and yes to this other one that's more aesthetically pleasing to the community. The last one, obviously, is the Xeriscaping Bill that has not yet been signed by the governor, but it has passed the legislature. And so this is going to happen within the next day or so if it hasn't happened already while I'm saying this, because, again, it's already on his desk. What has happened is back when we had Senate Bill 100, xeriscaping, at that point in time, the legislature said that the associations could not prohibit xeriscaping, and what's going on is we're going in and tweaking that bill. The bill used to say that an association could not require a majority or primarily turf grass on a property. Well, what they've done now is they've said an association cannot require any turf grass. So at this point, if your governing documents, if your guidelines, anything says there has to be any amount, it can be 10%, it can be a square foot of grass, that's prohibited at this point. You can no longer require that at all. Okay, now it doesn't mean that every homeowner is going to go out there and rip up all their grass. But if any homeowner comes to you and says, I want to xeriscape my front yard, and in the past you've required that there be a set number amount of square footage of turf in the front yard, you can no longer require the turf in the front yard. You're going to have to allow them to xeriscape. That does not mean they can rip up every living material in your front yard and put in all rock. You can still require drought-tolerant living material. You just can't require any type of turf. Okay. The other thing that is in the new bill, which is actually a little more helpful to the community than it used to be, which is an explanation of what happens during drought restrictions and watering restrictions. In the past, the wording in the statute basically made it very confusing if the association had any ability at all to enforce maintenance of your landscaping during water restrictions. Now it basically says the association can't force a homeowner to violate watering restrictions, but can in fact require them to water when they're allowed. So now if you have the homeowner who just turns off his sprinklers because he says, well, it's drought and I'm saving water, and his entire front yard dies, you can send the violation letters. Now you're going to need your neighbors of that homeowner to testify that we're allowed to water on Tuesdays and Thursdays, and never once on a Tuesday and Thursday did he water, and therefore that's why the landscaping died. Because if he gets up on the stand and says, no, I watered every Tuesday and Thursday, it just wasn't enough and it still died, the homeowner will win because, again, he did water during the drought restriction. So it will take more testimony, but because of the changes, actually, if you want to enforce your covenants during drought restrictions, you can enforce them. It will take just a little more testimony of the neighbors. Okay, so let's go back to looking at, what the ARC and their authority is going to be. When we're looking at the applications that are submitted, and we're looking at something that, let's take for example a shed, and the shed got submitted to the ARC. What is the scope of the ARC's authority? That ARC is limited to whatever those governing documents say. Again, that might be really open-ended authority from the declaration saying it just has to have pre-approval, or it might be very, very restrictive because there's a very complete set of guidelines that say that shed has to be no bigger than 8 by 8. It can be no taller than 8 feet. It must have a roof that matches the same roof or is the exact same material as the home. It must have the same siding as the home. It must be painted the same color as the home. You can have very, very detailed requirements, and if that's the requirements that have been put into writing into the guideline, that's what the ARC, the ACC, that's what they need to follow, is those very specific, concrete set of guidelines. Again, if you want to leave it open, that's certainly something you can do. It's much more difficult to go into court and enforce your covenants on a shed application if you don't have guidelines telling you what's allowed and what's not allowed. For example, if you're trying to say to a court, Your Honor, this shed isn't appropriate, the board or the shed, let's see if I can back up. The judge is going to say, what do you mean it's not appropriate? Well, if you have guidelines that say it has to be 8 by 8 wide, 8 feet tall, and this shed's 10 by 12 and 12 feet tall, it's very simple. It's a very easy fix. It's a very easy court case because you just say, Judge, here's the measurements, here's the photos, here's what my guidelines say. But if your guidelines are completely open and don't say what should be allowed, what should be approved, now you have to explain to the judge how it doesn't fit, how it's not in harmony with the rest of your community. Sometimes that might be simple. You might have a beautiful community that's all pueblo, it's all construction of a lot of stucco, tile roofs, and here in the middle of it is this ugly metal shed. Okay, very clear, simple for a judge to see that this metal shed really doesn't fit in the style or the decor of your home. But if it's not, if your community is one that has lots of different styles, lots of little details, and here's the shed that also has lots of little details, it's going to be very difficult to explain to a judge that these details aren't the proper details to go with your house. It's not the right color. It's not the right material. It's very, very helpful for your ACC to make decisions if you've already put in guidelines saying here's what we're going to allow. It also means you're going to have consistent application from this year's ARC to next year's ARC to 5 years down the road's ARC. It's going to make sure all your homeowners are getting the same answers. It doesn't mean that if you don't have those guidelines, we can't enforce it in court, but it is a much harder road. And it's much harder to design, or much harder for the judge to look at something and say what's going on. About an absolute restriction, that's the definition that says no shed. That's a shed. That's a pretty clear one for the ACC to look at. When it's covenants and stringent guidelines, the only thing that you have to be careful with in a courtroom is explaining how that affects your community and why it's important for your community. And they work really well if you have that explanation. And what I'm talking about is simple restrictions. I said, you can't do this, you can do that. Those are very simple, direct restrictions. Most of those are going to be in the covenants. Sometimes they're going to be in a rule. The discretionary ones are when you're talking about it must match. Okay, what's match? Match is given a lot of discretion because I might think something matches, but it might not be the same color. It might be a tan house and a cream outbuilding. Those match well together, they go well together, but they're not the same color. So your definition of match means you're going to give discretion to your community or discretion to your ACC who's making these decisions. So if you're going to do that, make sure you're very clear about what you're looking for. And make sure you're well informed. If a board doesn't have records of what's been approved in the past, you're not going to be informed and you're going to contradict prior decisions. And the minute you do that, you're going to have problems with your community. If you're looking at crafting guidelines, if you're looking at crafting rules to make it clearer, to make sure that you're consistent in your application, make sure you take out language like, we encourage homeowners to have the same color house, or you should take these steps when you're building something. Shoulds, maybes, could be's, encouraged. Don't do any good in the courtroom and will not win your case and will not make it self-explanatory to anybody. If you want no metal roofs, do not put, we encourage homeowners to use wooden structures and we encourage them to have shingles of asphalt or tile or whatever you want. Say, there shall be no metal buildings. Shalls, musts, those are the type of language that you want to have in your guidelines. Once you've gotten your guidelines, or once you've gotten your application reviewed and you're looking at what to do with your decision, I want to take some time to encourage you to remember you're dealing with a homeowner who took the time to submit and is trying to work within the community and trying to fit his ideas within the community structure. If you have plans submitted in front of you, you like 90% of that landscape plan, I want to encourage you not to deny the plans because of the 10% you don't like. That's the time to really use a conditional approval. That's the time you send it back and say, we conditionally approve this plan, and the condition is this 10%, meaning these 4 trees have to go, or these bushes have to go. Specifically deny the 10% you don't like and you don't feel fits within your community guidelines. Approve the 90% that's in compliance. You want to show the homeowner you're trying to work with them. Now, if you've got 50-50, yeah, deny it, but deny it with an explanation of what the problem is. Don't be sending blank denials back to your homeowner. It makes them feel like they're playing a game and that you don't care about their submission. If there's things that you can help them and explain to them, do so. Take the time to do so, because when you walk into a courtroom, you want to be the person with the white hat, and you want to show the judge how you took every step to help the homeowner understand the rules, understand the guidelines, and get what they needed, and so they could submit things properly. So again, remember that your options within, after you've reviewed the plans are approve it outright, approve it with conditions, deny it, but explain why you're denying it, and then finally variance. I want to talk about variance because variance isn't a given, all right? If your documents don't clearly say you have authority to give a variance, you don't. If your documents say that just the DRC has the authority to give a variance, then just the DRC has that authority. just like we started off and I said, who has the authority to review this to begin with? Is it the board or is it the DRC? The variance procedure is the exact same. It's generally limited in your governing documents. Who has the authority to give it? And it also is generally limited on what type of authority you have. And it's generally not this blanket, you can ignore the rules when you feel like it. It generally is, for very specific reasons, you are allowed to give a variance. Some of the most common ones are hardship, maybe topography. Topography is a very simple one and easy one to understand. Think of it this way. A lot of communities have a specific number of trees that are required per lot. Well, what if your lot happens to be the pie-shaped lot at the end of a cul-de-sac? And there's a requirement for 2 trees in the front yard. Well, when you're looking at that pie-shaped lot, there's no way you can get 2 trees in that front yard. So topography very clearly sets forth a need for a variance in that case. And it's appropriate to give a variance. Maybe what you do is the variance is instead of 2 in your front yard, you add 1 to the backyard. Okay, it makes it appropriate for the topography. Again, you're not asking for something impossible of this homeowner. But you don't give a variance because you don't like the rule. If you have a rule in your covenants that is not a rule that you like, now I've just merged ideas. So let me be very clear. If you have a covenant you don't like, you don't get to ignore it. You don't get to give variances around it because you don't like it. If the covenant is one that the community thinks should not be there, you need to amend your governing documents. I know it's hard to get that 67%, but you need to amend your governing documents and get the covenant removed. You don't just give a variance around it. If it's a rule, then take a board vote. Make sure that's what your community wants. Follow your procedures for adopting your rules. Get that homeowner input if that's what's required, and remove the rule that nobody likes. Don't give variances around them. Variances raise a tax in court, because every time you give a variance, you're giving that next homeowner that you choose to enforce about the argument of selective enforcement. Well, they gave Jim a variance, and Jim got to do what Jim wanted, but I can't do what I want. Okay, that's not a good process. So if you limit yourself on your variances and you only give them very, very, very selectively, and only when there is a hardship and only when there is a topography issue, then you're not going to be attacked in court on selective enforcement. And on hardship issues, if a homeowner chooses to install a complete roof and never bothers to get approval and never bothers to ask what type of roof he got, and then he finds out that, of course, he installed the wrong kind of roof and it's going to cost him a lot of money to fix it, that's not a hardship. That's self-caused by him and his refusal to follow the rules. That's really not a hardship like what the documents are talking about. A hardship is when a homeowner association has a prohibition against rentals and the homeowner gets transferred out of state by his boss and he has no choice and he can't sell his property. That's a hardship. That's the type of thing that he didn't cause, he didn't do anything, and yet now he's in a bind because of the rules and he's asking you to grant a variance because of it. So again, they should be very seldomly given, and when they're given, it should only be for the reasons allowed in your documents and only by whoever is allowed to give them, the DRC or the board, whatever the case may be. Okay, so what's the process that we want to follow when we're looking at the documents and we're looking at an ARC problem? It's going to be the same policy, the same type of letters that you use anytime there's any other covenant violation. You're going to go through that same situation where there's going to be a warning letter, then there might be a fine notice, there might be hearings if the homeowner requests it. The only distinction in an ARC situation that's going to be separate and unique to the ARC situation versus any other type of covenant enforcement is a cease and desist letter. Now, what do I mean by a cease and desist letter? That's the letter that goes out because you caught the guy in the middle of the process of building and installing. That might be that the board member was driving down the street, saw them start tearing off the roof of a house, so you know they're about to do new shingles, and that board president knows there's been no application for approval for new shingles. When that kind of thing happens, the best thing an association can do is either A, have the board president stop right there, give a holler to the homeowner. If he's up on the roof, talk to the foreman, say, hey, you know, this has to have an approval process before you can do this. This is kind of risky to proceed. You might be spending money that you're not going to get back. This is a risky thing. There's no need to get in an argument. If the guy says, look, I'm going to do it anyway, you thank him for their time and you go on. You then go to the office and you have your manager follow up on a letter saying, hey, the board president saw this. He stopped and told you you didn't have approval and you don't have approval, and without approval, you're not allowed to do this. That kind of letter is that cease and desist letter. It talks about the fact that somebody may have stopped and verbally said something, and it also just puts them on notice immediately that what they're doing may not be allowed, may be a situation that they're going to end up ripping off again to bring it back into compliance with the covenants. So that's an addition that you want to add to your packet as far as what has to happen when you're looking at any kind of ARC situation. Otherwise, again, you're going to follow the process that you have to follow for any covenant enforcement action. And talking about covenant enforcement action, you've always got to have your due process. This is always required. This due process is, again, making sure we're following the rules of Kiowa, making sure that Colorado Common Interest Ownership Act, Kiowa statute, is met and complied with. That means no fines unless you offer a hearing first. It doesn't mean that you send out that warning letter saying fix it within 10 days, or you may be subject to a fine and 10 days come, and then you send the letter that says, hey, you've been fined. That's not in compliance with statute. The statute requires that if your first letter is a warning letter, your second letter has to be a fine threat. So it has to be, it's been 10 days, you haven't fixed it, you may be fined. Would you like to have a hearing? If you'd like a hearing, send the request in writing to me within a set number of days. That notice and opportunity for a hearing has to predate any fine. If you don't have that, if there's not that notice and opportunity for a hearing, no fine is going to be upheld by a courtroom. Be prepared when you have the hearing, if the homeowner asks for a hearing, to disclose the name of the witnesses. Again, this does not generally be such an issue in an ARC situation, because most of the time in an ARC situation, it's they painted the house purple, they painted the house orange, they put on shingles that weren't allowed. Anybody who drove through the community can see it. It's really not going to be the he said, she said that you run into with a lot of different covenant issues. However, you still need to know that if the homeowner wants to know who turned in the complaint first, and it's a written complaint, they're going to get a copy. Those two statutes that are on that slide are the Nonprofit Act, as well as Kiowa provisions that require that if a homeowner asks for copies of documents of the association, copies of complaints about their property, you do have to provide them. Again, if your homeowner asks for a hearing, you have to grant that hearing. And if in fact the homeowner brings witnesses, you have to allow them a chance to put those witnesses on. One of the bigger things that I see happening is homeowners ask for a hearing and the board wants to go into an executive session. You cannot go into executive session for a hearing on a violation of covenants. That has to be open, just like anything else that your board does at a board meeting. It cannot be an executive session. So have your hearing and then issue the decision. If the decision is set forth in your documents that has to be issued within 10 days, make sure you issue it in 10 days. Again, we're asking a homeowner to comply with the rules. We need to comply with our own rules. So if our rules say that we're going to issue a decision in writing, we're going to issue it within 10 days of the hearing, then we're going to do that. Again, follow your own governing documents. Okay, so your third password that you need to know is SUMMER, capital S-U-M-M-E-R. All right, so if we in fact had our hearing, then the question is, can there be an appeal? I often see board members, homeowners, everyone just assume there's some right to an appeal. If your governing documents don't give a right for an appeal, there is no appeal. And honestly, if you have a small community, it's almost impossible anyway, because half the time the DRC and the board are the same body. So who's the appeal going to be to? This morning I'm the ARC and I wear the ARC hat, and then you want to appeal, so I take that off and put on the board member hat, and I'm the same person. Again, if your document's set up, there's a right for an appeal, make it a valuable right. Have different groups reviewing the documents so that if in fact there's an ARC, they can appeal to the board. If there's no right to an appeal, then there's no right to an appeal. It's that simple. Make sure that in fact there's authority, and that if the authority is this, then in fact it's covered. Finally, the last slide that is here is in fact one on statute of limitations. Obviously, one of the things that comes up often in ARC situations is something's built. If something is built, you have 1 year from the date it was built to file suit in the courtroom and go after them to remove it. If you don't file that lawsuit within 1 year of finding it, then in fact you are going to not be able to file suit. So again, dates become critical again. When you see that building start building, mark it down. When it's finished, mark that date down, because 1 year from the date it was finished, you got to get in that courtroom. And your hearings and your letters aren't going to slow that up. So again, make sure that in fact you follow the statute of limitations and you know when something was built and when something was installed. Okay. Do you have any questions? Anyone submitted any questions? All right, well, it looks like we don't have any questions, so thank you all, and that'll end it for today.